Hello. Well, today I'd like to talk to you about an insolvent charities case, and this is one of our earlier insolvent charity cases, and it relates to Liverpool Heart Hospital, as it then was, and the case, of course, is the Liverpool and District Hospital for Diseases of the Heart, and Attorney General, citation 1981, square brackets, Chancery 193. The case, of course, involves hearts, and here's one that I've borrowed from the anatomy school as an aide-memoire that will remind you of what a heart looks like. You've all got one, hopefully. Here's this one. So why is a hospital that is concerned with how we look after and treat hearts of note to the law of insolvency, and in particular insolvent charities? Well, in 1981, the case of Liverpool and District Heart for Diseases of the Heart and Attorney General came before Mr. Justice Slade, where he had to consider a heart disease research and treatment charity that was being run through a company limited by guarantee. So it's a charitable company we're dealing with, as opposed to a charitable trust. And that company was called the Liverpool and District Hospital for Diseases of the Heart. This was the first case to involve the Attorney General in a winding up of a charitable company pursuant to the provisions of the Charities Act 1960. The company was going through liquidation as its main activity had been transferred to the local National Health Service hospital in 1948. And that was as a result of the National Health Service Act 1946. The Liverpool and District Hospital for Diseases of the Heart became vested in the Minister of Health in July 1948, and cure of heart disease and other ailments continued for a short time under the auspices of the Institute of Research for the Prevention of Disease. But eventually this ceased in or around December 1968. These research assets did not vest in the minister. In 1978, the Attorney General brought a successful winding up petition to wind up the company, and there was a surplus of approximately £14,727 in 1979. In addition to the lack of statutory returns, the executors of the late Mrs. Edith Hellon had received no receipt following a gift to the charity by the testatrix. So the question before Mr. Justice Slade was whether the assets of the company should be used first in satisfaction of the company's members, or secondly, whether any surplus should be distributed to an institution or institutions having similar objects to those of the charity, i.e., should the value be distributed si pre. The second destination for the funds adhered to a clause in the company's Memorandum of Association. Well, Mr. Justice Slade held that the company was both the legal and beneficial owner of the assets. Whilst operating as a charity, the company was nevertheless not a trustee over the fund. Therefore, on winding up, the assets were to be distributed to the company's members pursuant to the relevant statutory provisions. The constitutional arrangements in Clause 9 of the company's constitution, however, then kicked in. This meant that as the company held assets for strictly charitable purposes, pursuant to its constitution, that a scheme would be directed on the premise that the property and funds of the company were applied si pre. The judge observed, quote, "In my judgment, the court, in exercise of its jurisdiction over charities, can and should give effect to this provision," that's Clause 9 of the company's constitution, "by directing a si pre scheme," close quote. So the case has been cited as authority for the proposition that the court, quote, has C. Prey jurisdiction on winding up, close quote. And that's Hanbury and Martin's 15th edition, 1997, at page 433. There are, however, some issues with the case. Whilst Mr. Justice Slade is undoubtedly correct in law in terms of the legal title, the effect of his judgment as regards the beneficial interest is to neglect or to overlook the unique nature of the objects of the company. This was not a commercial organisation operating towards shareholder wealth maximisation. It was a charitable company. If the company's position is analogous to that of a trustee, to debar this from being found is to hamper the charitable purpose. However, we know that the C. Prey mechanism within the Constitution eventually facilitates that charitable purpose. So perhaps Mr. Justice Slade was correct after all. Counsel for the Attorney General, and therefore the person acting on behalf of charity and charitable purpose facilitation, was John Mummery QC, as he then was. He argued for Clause 9 of the Constitution to be operative and for the money to be applied C. Prey on the winding up of the company, because the members of the charity had no interest in its assets. As we have seen, he was successful in part, but not on the company occupying the position of trustee argument. As part of his argument, he noted that, quote, the Companies Act 1948 does not provide a complete code regulating the affairs and assets of a charitable company on its liquidation. It is necessary to examine the provisions in the memorandum and the chapters and to the general principles of law concerning charitable trusts and their administration by the court. It should be noted that the judgment in Liverpool Har allowing C. Prey for property held in trust-like circumstances by charitable companies is a subversion from the normal rule that only charitable trusts can deploy C. Prey. So it's a very interesting early case on charitable insolvency, and one which highlights how a charitable company's constitution specifically can save the assets for general charitable purpose, and in this instance through the mechanism and operation of the C. Prey doctrine. For now, I bid you goodbye.